How do I know whether or not I am eligible to adjust status? We have talked about this before, but we are going to give you some pointers in this video. So how do I know whether or not I'm eligible to adjust status? Remember, adjustment of status is a process by which a person can apply for a green card without that person leaving the United States. The first question you have to ask yourself is, do I have an approved petition? Okay? Do I have an approved petition? That petition can be a family-based type of petition. It can be an employment-based type of petition. It can be a humanitarian-based type of petition, or it can just be self-sponsored type of petition. When we talk about family-based, that's when we have the form I-130. People usually file that form concurrently with a green card or on its own, depending on whether or not the visa is immediately available. And when we talk about employment-based, most of the time is I-140. And sometimes it could be I-360 when we talk about religious institution filing for you. And when we talk about humanitarian-based type of petition, that's when we talk about asylum, I-589. Asylum can be approved by USCIS directly, or asylum can be approved in court, right, in removal proceedings. And when we talk about humanitarian, again, we have U visa, we have T visa. And when we talk about self-sponsors type of petitions, we use again the form I-140, and then that's when we talk about EB1, EB2 type of petitions. Assuming that you have an approved petition, then you move on to the second question. And the second question is, how did I enter the US? How I got here, okay? Depending on what type of visa you got here with, that also can determine whether or not you're eligible for adjustment of status. Remember, we've talked about it previously. Certain individuals, as a matter of law, they can just simply not adjust status. They have to go outside of the United States, go through consular processing, okay, and ask for the immigrant visa at the U.S. consulate or embassy outside of, meaning that you came with a B1, B2 visa, okay, basically lawfully entrant. So basically you enter the U.S., you've been inspected, parole, or that. So, but if not, unlawful entrant, then you have to check eligibility under 245I, which we talked about it too previously. You're not eligible under 245I, unlawful entrant, then you might have to go outside of the US in order to cancel the processing. Now you go to the third question. Am I eligible for an immigrant visa? Obviously, if you have an approved petition, so it clearly means that you're eligible, right? Then you move to the fourth question. Is a visa, in my case, immediately available? Well, in certain category of people or category of petitions, you have to wait on the line until the visa becomes available. We're talking about U visa, T visa, you have to wait on the line. Even I-589, you have to wait for a full year after being granted asylum prior to applying for asylum. Cancellation of removal, too, you have to wait until the visa becomes available once you've been granted cancellation of removal in court. But qualifying relative like spouses, parents, US citizens, their visa are immediately available, so they can, after being granted petition, then they can just go ahead. Fifth question will be, am I admissible to the US? That's when we go and start talking about criminal activities or immigration offenses. If you have a crime, you have to find out whether or not a waiver is available under your circumstances. If you have an immigration offense, which is fraud, frivolous asylum applications, falsely claiming U.S. citizen, those two things, frivolous asylum application, falsely claiming U.S. citizen, no waiver is available. So you can just cross that one out. Ask yourself if a waiver is immediately available. if a waiver is available under your circumstances. And if a waiver is available under your circumstances, then you go ahead and say you are eligible to adjust status. So you have to go through those process, case assessment. But sometimes this can be overwhelming, okay? Because there are laws, there are things that you might not really understand and you need explanation for it. That's when we're here, right? We're here to help you assess your case, and we're here to advise you properly on whether or not you are able to adjust status, eligible to adjust status. The final question sometimes is, I am in removal proceedings, can I adjust status? Well, if you have an approved petition in your removal proceeding, you can adjust status before the immigration court if the case is open, right? You have an individual hearing coming up, then. But if the case is it's closed, in other words, the case you have been ordered removed, technically you're still in removal. You cannot go back to USCIS and adjust status because the court has final jurisdiction on your case. Then you have to first of all try to get jurisdiction outside of the court and give it back to USCIS. That's where you reopen the case and terminate removal proceedings, and then go back to USCIS to adjust status. If this sounds like too complicated for you to start self-assessing your case, please call my office 202-751-2180. We're here to help you. You can email me too as well, Bijoux.ngwandaesq @gmail.com. Again, we do charge for consultation. But you can go ahead and email me if you want to assess your case. Then we can find out, we can explain you, we can find out whether or not you're eligible to adjust status. Until next time, bye-bye.